Hi, everybody. Welcome to our estate planning webinar, More Than Money, Using Your Estate Plan to Leave a Legacy. I am Sara Lohse. I'm the Director of Marketing here at BFG Financial Advisors, and I'm so excited to have not one, but two awesome guests joining me on this. You're going to get a financial perspective, and you're going to get a legal perspective, which is so much fun. So I'm going to let them introduce themselves. Eric and Jill, go ahead.
Well, my name is Eric Brotman. I'm the CEO of BFG Financial Advisors here in Lutherville, Maryland. Have been in practice since 1994, and we work with families all across the United States, and we help them with their financial planning, wealth management, and plenty of legacy planning. So I'm excited to be here and excited to be alongside my friend Jill Snyder.
Hi, I'm Jill Snyder. I have a law practice called the Law Office of Jill A. Snyder that focuses exclusively on estate planning, small business planning, and probate here in Baltimore County, Maryland.
Wonderful. Thank you guys both for joining us. I know you're going to give a lot of awesome information to everybody that's online with us right now or watching it later. We're going to start the way we always do with our exciting disclosures. And then let's get started. First, let's kind of start with the basics. What is an estate plan? And we're going to get the financial answer and the legal answer. So how about Eric, you take that first.
Well, I'm delighted to, and an estate plan let's break it apart. It is planning for your estate. So let's first say, what is an estate? An estate is your stuff. To quote George Carlin, it's all the things that you possess, whether they're physical and tangible, whether they're intangible, whether they're online. They're everything from your copyrights and trademarks to your retirement accounts, to your home, to your automobile. It's your stuff. Now, planning around that on the financial side is often the piece where you say, well, what's going to happen to my stuff if I'm not here? Am I married? Do I have former spouses? Do I have children? Do I have grandchildren? Do I have charities I want to support? And we're going to talk a lot about that this morning. But realistically, an estate plan on the legal side is a lot more than stuff. And I know Jill's going to talk about that. But for the financial purposes and just looking at the financial assets, it's really about what's going to happen to the possessions that I have, the wealth that I've created when I'm no longer here, and who's going to take care of it if I'm here but can't take care of it myself. So that's the very basic answer on the financial side, and I'll pass the baton to Jill.
So estate planning from the legal side is planning for both your death and your incapacity. So the essential documents that are incorporated into a typical estate plan are the will, which talks about what happens after you die, where your stuff goes, who's in charge. It can do a lot more than that if necessary. It can help you with tax planning. It can control distributions to beneficiaries. It's the only way to deal with guardianship for minor children. And then the other documents that are typically incorporated into an estate plan are all documents that affect you if you're alive but not able to make decisions. So one of those is the living will, so that you can make your own end-of-life decisions, really as a gift to everybody else, but also to make sure that your wishes can be honored and communicated if you can't communicate them at the end of your life. And then there are your two powers of attorney. There's a power of attorney for healthcare, so that somebody is authorized to make your day-to-day medical decisions if you're unable to do so. The most important part of that document these days is the HIPAA release that's incorporated into it, so that the doctors get permission to talk to your agents so that they can make good decisions about your care. And then finally, and arguably your most important document, is your financial power of attorney. Because not just because it deals with money, but if you don't have a financial power of attorney and you become incapacitated, nobody has access to your assets to take care of you, to take care of your family, without going through a full-blown court-appointed guardianship. And I'm sure Eric has seen bad scenarios where this hasn't been in place, and it's a problem that can be so easily avoided by having your documents.
Can I ask let me ask Jill a quick question that I think she can add some color on this before we move on, and that is, how often do you think your estate plan should be looked at? When is the right time to do it, and how often does it need to be reviewed?
Yeah, that's a good question, Eric. So typically I tell people that every 3 to 5 years or whenever there's a significant change to their personal or financial situation, that's when it's important to review your estate plan.
Do you think that's also true when you move from your state of residence? If you move from one state to another, some states I think have reciprocity, others don't, and there are some specific laws in each state. So is it important to have an estate plan in your state of residence?
Yes and no. So the answer, it's a typical lawyer response, right? So the answer is when you have a will and it's validly executed, it will be honored everywhere else. But as you said, the rules could be different. So it doesn't need to be the first thing that you do when you move, because your current will remains valid, but because there could be differences in tax laws or there could be state-specific forms that'll just make it easier to implement and use. I think it's important whenever you are considering an update to have it reviewed and refreshed by an attorney who's licensed in the jurisdiction where you're living.
Terrific, thank you.
All right, well, with that, this has been very upbeat and positive. So let's talk about something that isn't as negative or morbid, I would say. When you talk about estate planning, is it only about money, or is there something maybe more important that we can talk about?
So you don't want me to bring up end of life care and persistent vegetative states and those kinds of things this morning?
We'll cover that next.
Oh, good,
Yeah,
because
we're
everyone
gonna bring
likes to
in the
talk about.
funeral director after this.
That's good. Everyone's going to be very upbeat after that conversation. So isn't estate planning only about money? No. And you might think as a financial advisor that I'm most concerned, or our team is most concerned about the money aspect of it. That is really only a portion. And I think that there is planning around not just your stuff, but the things that are most important to you, the things you hold dear. And most of those aren't things, they're relationships. A relationship with your alma mater or your place of worship or your or where your kids have spent their time, their formative years. It could be relationships with other human beings, your own family or close friends or other people. And I think there's also a lot about stories. You know, for me, one of my favorite parts of doing estate planning and doing multi-generational financial planning is talking about visions and values and stories and how to convey those things. And so we're going to talk a lot about legacy this morning, and there's more to estate planning than just money. And some of it also has to do with what your wishes are. You know, if you have 3 children, your 3 children are liable to be entirely different human beings. Even though, and you could talk about nature and nurture all day long. If you have 3 kids, I don't know, for everybody out there who has siblings, think about your siblings and wonder, are they exactly like me? And the answer is usually no, even if they're twins. And so when you leave property behind, any type of property, or when you choose who's going to be responsible for you, it's important to leave folks empowered, but not to arm them with something that could be dangerous for them. So in other words, if you have a grown child who has a gambling issue or a drug issue or marital issues or other types of things, it's important to try to preserve and protect not only the wealth you've built, but also to protect your heirs from what I like to refer to as predators and creditors. So yes, there's a big emphasis on money and on your net worth. But there's also a lot about, I believe, a lot about who you are, where you come from, why things are important. Like the why matters. Not just the how did we get here, but why did we choose this? And communicating with family is so abundantly important so that there are no misconceptions. I don't know of a better way to ruin Thanksgiving for the next 50 years for your family than by not communicating some of your wishes, your values, or leaving behind something that's either incomplete or that's a surprise.
Okay, and just to follow up on what Eric said, I completely agree that estate planning is more than money, a lot more than money, and a lot of it is focused on the values that you want to transfer and the goals. So, you know, when I mentioned the estate planning documents, of course, outside of the money, it talks about how to plan for if you can't make decisions. So that's an obvious non-monetary benefit to estate planning. But I also think that it's important when I talk to families about their estate plan is to talk about their goals and their values and how to have that show and transfer in addition to their money. So one important thing is a lot of times people focus on the transferring of money without focusing on teaching their children how to receive the money. So, people are often not comfortable talking about money and that kind of thing, and they never get to the point of, so one day there will be this money, and how are you going to know how to handle it if I don't talk to you about it? So that's important. And I think another huge value in estate planning that I hear from people is that they're hoping to preserve family harmony and avoid future conflict. And the more you lay out, the less there is to fight about. So I think that's important. And I also think it's important whenever the family can, I encourage them to have these conversations with their children or family members while they're still alive to be able to explain why they made the decisions that they did and how they see things going. Because what appears in a legal document, for example, leaving uneven amounts to different beneficiaries, can be perceived by the beneficiaries as a demonstration of who loved whom more and that kind of thing. And there could be a really good and important reason why the decision was made. But if you go to the grave with it, no one will ever know that reason. And it can breed resentment amongst the siblings. The other is the charitable piece, which I think we'll talk about more when we get to legacy. But it's important to think about when you're doing your estate planning how you want to be remembered.
So when you do estate planning for an individual or a couple, how often do you suggest pulling in either the beneficiaries or heirs or the responsible parties? How do you encourage folks to notify them? Do you include them in the process sometimes? Is it always different based on family dynamics? Like what are the best practices there that folks can take away from this?
Okay, no, that's a good question. So typically, I prefer to speak to the clients separately from their family at some point so that I feel confident that they're making their own independent decisions. And it's also for protection of challenges to the legal documents in the future. You don't want it to be that one sibling, attended all the meetings and that sibling got more or got all the roles. And then there's a question of whether the person who created the documents was being unduly influenced. So although I like to include, I need to be careful about how I include so that everything is transparent and doesn't lead to the appearance of any kind of undue influence. When families are included, I would say at the very bare minimum, I make sure that once documents are signed, the clients inform the people that they've designated in the various roles, not necessarily all the nitty-gritty details or even copies of the documents, but to make sure that they know exactly where their documents are kept, that I've got a set, and oftentimes they're also shared with the financial advisor, and to make sure that the families know who to go to if something happens. Beyond that, I encourage people strongly whenever there is what I call an unnatural disposition. If more is going to be left to one person or something is going to be left in trust for someone rather than directly to one child, but have a different plan for another child, I just think it's important when the family can to explain the reasoning for why they made these choices so that, again, there are no surprises and everyone understands what was behind it. And again, a lot of that is just to avoid the resentment amongst siblings later. That's so common because all of the estate fights that I've become aware of all seem to be about the money, but never actually truly are about the money once we get down to the heart of it. And it goes back to some childhood resentment that they think the parents loved this one more, or the parents did more for this one and less for that one. And so that's why I think that the more that is discussed during lifetime, the less people are left to wonder and assume the worst later.
If I can add to that, and that's excellent perspective. If I can add to that, I think it's important to know that just because you're introducing your kids or grandkids or other family members to your financial advisor and discussing this, it doesn't mean you have to quantify this. See, a lot of people are, and rightly so, are concerned that if their kids knew what they were worth, for example, that it would disenfranchise them, or that it would potentially create a situation where they weren't as industrious, because they would be in the back of their mind knowing, it's almost like knowing there's a safety net before you get on the High Wire Act. So it's okay to have qualitative discussions that aren't necessarily, in my opinion, that aren't necessarily quantitative, so that you can say, this is who I'm naming, and this is who's going to be trustee, and this is where, you know, if you're leaving responsibility for your children to one sibling versus the other, to be able to say it's because of geography, or it's because they, you know, my sibling already has kids, or there's reasons behind it. A lot of this doesn't have to do with quantifying it. There's so much baggage around money.
You're
There's so much
absolutely
people who are wealthy by any reasonable definition sometimes are embarrassed by the wealth they've amassed. Sometimes they're embarrassed that they didn't amass more, because there's this keeping up with the Joneses thing. Sometimes parents say, oh gosh, I wish I could leave behind more. I just didn't build it. And others say, my kids don't need a thing. They're in great shape. I paid for their education. I'm going to enjoy every dime. And there's a total spectrum of different qualitative and decision-making things, all of which are fine. It's just, I think, really helpful to discuss it in advance. So to your point, communication is important, but you don't have to necessarily let kids know that they're going to receive X dollars at some future date, because that can actually create harm in my experience.
I agree.
Yeah,
And
that's a
there are
great point.
instances, sorry, there are instances where it makes sense not to give money directly, even to responsible children. And I think that's where it's important to explain to the children, you know, I know that you can handle the money, but I also see that you and your spouse have, you know, had some conflict, and, you know, I'm hopeful and optimistic that you guys will be able to work everything out, but because there are no guarantees, I just want to make sure that this money is protected and available to you in the future. And that's why I'm making this choice.
Well, and segregating assets that you inherit is also often a best practice, even if you're in a terrific relationship with your spouse. If you commingle inherited money with other monies, it becomes marital, it becomes shared. Whereas if you keep it separate, in most jurisdictions, if you keep it separate, it's not considered as part of that marital pool. And there's exceptions to that. But, you know, sometimes if one of the two spouses inherits money, there's this tendency to say, oh, I have to make it joint with my husband or my wife, because it feels somehow like the right thing to do. But it's also okay for us to tell them, you know what, you can keep that separate. We want that ultimately to be used by your spouse if he or she outlives you, but we want to make sure it gets to your children and stays in your bloodline. And every family's different, but that tends to be something folks are aware of and at least want to talk about.
I agree, but I've definitely found that it's easier said than done when you're the one married to the person and having to get in bed with them at night to explain. So sometimes I tell the parents, better for you to be the bad guys that kept it separate than to put that burden on your child to
Yes.
say, I want to keep it separate. Let
Yes.
the
And
dead one be the bad guy.
I'm also happy to be the bad guy when I need to be. So,
And I'm happy to blame my parents.
so you're right.
Before we move on, so we've been talking about estate planning, and we're going to get into really the meat of what we're talking about, which is leaving a legacy. But before we do, we did have a question come in, and now for anybody who has a question, there is a questions tab. Feel free to send them over whenever you have them. If we don't get to them during, we'll get to them at the end. But we had a question from Gabriella, who asks, what if you go abroad for a couple of years? Does everything still apply with estate planning?
That's a great question. I'm going to defer to the council for that, because I suspect, like every other answer, it's, well, it depends. It depends where and for how long and so forth. Yeah.
So, you know, I would say it depends on where your assets remain. You know, if your assets are all in the United States and you're just temporarily abroad, then yes, everything that you've set up should still be enforceable. It's problematic when you start purchasing property outside of the country, because there are tax implications to that. There are certain countries that have tax treaties with the United States so that you avoid double taxation, and there are other ones that do not. So, you know, it would have to be specific to where the person is relocating and get specific international tax advice.
Great. Thank you for sending that question. And again, if anyone else has questions, feel free to send them in the questions tab. So let's move on to why should I care? Is leaving a legacy something that everyone should care about, and why?
I think as a human being, it's important to think about how you want to be remembered and what impact you want to have on the world. And hopefully it's one that you will be proud of and want to leave the world a better place than you found it on lots of different levels. I think people confuse leaving a legacy with some form of immortality, and slapping your name on a building to me is not the same as leaving a legacy. I don't know about you, but where I went to college, every building had a name on it. And I knew what the names were, but I knew nothing about those people. In fact, it didn't matter to me. It mattered to them at one point, but it didn't matter to me as a student. And that's not to suggest we shouldn't do naming opportunities. And if that's important to you, by all means do it. But to me, leaving a legacy is leaving behind your visions, your values, your stories, and continuing to create abundance for your family to the best of your ability in as eternal a way as possible. So the financial legacy, it could be an endowed scholarship someplace. It could be leaving something behind at your place of worship or your educational institution or a medical facility or someplace where you can really impact lives in a way that's personal to you, that matters to you. But it's also making sure that to the extent you can, you navigate a very challenging tax law and series of tax laws to try to keep as much of your wealth, and we can define wealth lots of different ways. Everybody thinks of wealth in a different way, but even if you don't think you're a wealthy person, you have some wealth. And so to keep as much of that in the hands of your loved ones and their heirs and your family, that creates abundance and opportunity in an ongoing way. And there's lots of ways to do this. You know, one of them is through philanthropy. It could be setting up a donor advised fund and naming your kids to manage it so that your kids get to be the ones doling out some of your charitable contributions. It means they're going to be meeting all the right folks. It creates influence for them, and it also teaches them the value of giving. That's one example. Very wealthy people look at personal foundations or private foundations. And that's certainly an option, though not for the mainstream, not for most. For most, it's really going to be about leaving something behind that's tangible and meaningful. And one of my favorite things that I've ever seen is doing videos, actually taking digital videos of your loved ones while they are alive, obviously, and while they can tell their own stories, so that you can hear it from them about how I met your mother, or where we grew up, or where we went to school, or why I became an architect, or whatever it is. There's so much history there. And I think about, in my own situation, I think about my daughter who doesn't remember my father-in-law because he passed when she was very young. And to me, that is insanely sad. And there were ways to prevent that. And I've tried to ensure that that can't happen with her other grandparents, because I don't remember my great grandparents. I remember my grandparents, but my child will never see or hear or really know my grandparents. Their stories, which are still with me, every generation as it tells those stories, it gets a little further and further. It's like the game of telephone. It eventually sort of just devolves unless you've captured it in a meaningful way. So to me, leaving a legacy is a form of immortality that is altruistic, that is not designed to be selfish as much as it is to be thoughtful. And some of that is financial, but lots of it isn't.
Okay, and Eric, you stole my thunder a bit because I agree with everything you said. The one different perspective that I want to add to that is one of the greatest values of caring about leaving a legacy and thoughtfully considering your legacy is that it really guides how you live your life. It's not just about after you die. But if you live your life thinking, how do I want to be remembered? What's important to me, and what do I want people to say about me in my eulogy? and how, what did I show that mattered? I really think that it can have a profound impact on the way that you live your life. So, it's not just a morbid what happens after you die. In terms of ways to leave a legacy, Eric touched on a lot of them. I'll try to bring up a couple that maybe he didn't mention. You know, the obvious is through the estate planning and the leaving money to your descendants, but you can also have a significant impact by advancing the development or innovation in your field of work. You could be a mentor where you pass along your skills. You can, you know, pass down family traditions or recipes, and you could start a new program in your community. And importantly, if you're a business owner, you can really teach the next generation how to operate a business instead of just like I talked about how you don't want to dump money in uneducated people's hands. You don't want to dump a business in an unprepared beneficiary's hands if you want it to actually succeed. So I think that these are all things that show that it goes so far beyond just passing money when you're doing your planning.
Yeah, that's a great point. And now, Eric, you had said something about not just slapping your name on a building if you want to give to a school. And it made me think that one of the things I know you're really proud of is how we have incorporated giving to a school in a way that's a little more meaningful. So maybe just as a personal example, do you want to talk a little bit about that?
Oh, I'm happy to. We started the Brotman Financial Group Emergency Scholarship Fund at Stevenson University, which is a local school here in Baltimore County. And we started it a number of years ago. And it was actually during a hard hat tour of the stadium where I was looking at naming opportunities when I realized that was less impactful to me than doing what are called gap scholarships. And so for us, recognizing that freshmen, when they come into college, they get a financial aid offer that's level for 4 years, but tuition's not level for 4 years. So by the time you're a junior or senior, you could run the risk of not having enough resources to finish school. And particularly for kids who are borrowing, and this show is not about student loans, though we could talk about them forever. If you've borrowed money to get a degree and then you aren't able to finish that degree, that is the worst conceivable outcome from a student loan perspective. So for us, it was a way to make sure that young people could finish and could graduate. And the program has been so successful that it's now spread and become an entire corporate philanthropy program for the university. There are, I think, a few dozen corporations that are doing this, and we've hired 7 or 8 young people from Stevenson because of the networking that we've done, being on campus and being part of that scholarship program. It has been a wonderful relationship. And, you know, now I'm trying to teach our younger employees, particularly alums of Stevenson, to give back in lots of meaningful ways also, because I think it is a self-fulfilling prophecy to grow this and to make a difference to more lives. And that whole pay it forward thing, I really love it. So hopefully that'll catch on. Thanks for mentioning that, Sarah.
Yeah, it's something I really love that we do here. So I thought it was worth mentioning a personal example. And now we'll move on to kind of the how of this. What are the pieces of that estate plan that can lead into the legacy? I know Jill mentioned some trusts and you mentioned some donor advised funds. How can someone listening to this really kind of get moving with building their legacy through their plan?
Well, I stole Jill's thunder on the last question, so I'm going to let her pay me back right now. And I'm going to let her take this one first. And then if there are any loose ends, I'll tie them up. How's that?
That's fair. Thanks, Eric.
Sure.
So, anyway, and I'm so happy to know that BFG does that. And I can't believe I didn't know that, considering how I know BFG. I think that's something that we should all know. And maybe I'll jump into, well, it'll apply to this. So first of all, I did mention trusts and just wanted to explain a little bit what a trust is and how it can work to help you leave a legacy. So when you're leaving money to somebody, you can just leave it as a direct outright bequest, where after your estate administration or after the beneficiaries on an estate, on an asset are determined, the assets can transfer directly to the beneficiaries and the beneficiaries can do anything they want with those assets. The other option is to do it in trust, where basically there's a gatekeeper between the beneficiary and the money. So a trustee can be a professional, a trustee can be a family member, There are certain people I don't recommend as trustees. For example, I always try to persuade people not to have siblings be trustees for each other. That's a recipe for disaster, to have one be the keeper of another one's money, and have them be put in a position to either say no to a sibling or to potentially not honor the wishes of the person setting up the trust. It's really a no-win proposition. So oftentimes we set up trusts where they're just distributed over a period of time, when children reach certain ages, and they can, through the lifetime of the trust, request distributions for the things that they need, but they don't get a pot of money dumped in their hands until they have more maturity and more experience and more incentive to make their own way first. Or these trusts don't have to be distributed at certain ages. They can go on for generation to generation. So, that's one way to handle it. Another is through different charitable opportunities. There are donor advised funds, like Eric mentioned, where you can have money that you contribute to a donor advised fund, and then you can make grants from your donor advised fund out to different charities that are meaningful to you. We've personally set this up and have our children as the successor advisors. We've included them in the decision making now for the grants that we make. We talk a few times a year over what's important and what stands out to our children as places to make the grants now. And then in the future, they'll hopefully be prepared and know how to continue to make those decisions when we're not here to make them with them. One other opportunity that exists is to use a vehicle like life insurance. And we also have personally done this, where I thought that for me to give, X number of dollars a year to a charity that's a relatively small amount might not have meaningful impact. But if instead I use that money each year to pay for life insurance premiums, with a significant death benefit going to the charity at my death, then I feel like I can make a more significant impact at that time. So there are tools. There are also charitable remainder trusts, where you can have trusts that give an income stream to a beneficiary for the rest of that beneficiary's lifetime. But upon that beneficiary's death, the remainder will go to a charity. So there are all kinds of tools available to leave your legacy, both from the financial transfer to the next generation and to your community.
I would love to say you stole all of my thunder, and you did, but I have 2 or 3 things I can add. Just from our perspective, some of the things that people sometimes forget is, number one, beneficiary designations are so important on various types of accounts, because they actually supersede your will or other legal documents in a lot of cases. So if you've got an IRA account, or you've got a life insurance policy, or you've got a 401k at work, naming beneficiaries on those accounts directly is incredibly important. It's important for tax reasons. It's incredibly important for dispositive reasons. And if you don't adjust your beneficiaries, it can create all kinds of family issues. For example, if you have a 401k at work and you've been working at this company for 20 years, and during that 20-year period, you had 2 more children, your 401k beneficiary could say, I leave everything to my spouse, and if my spouse is gone, I leave it to my 1 child. But now you have 3 children, and you could accidentally disinherit some of your kids. You could also have gotten divorced or remarried. I can think of no thing that any human would want when their spouse dies than to find out that their former spouse before you was getting their retirement plan or their life insurance policy or other things, unless there was some reason why you did that on purpose and it was communicated.
I've seen that happen.
I've seen it happen too. And the other thing, we do a lot of work with big companies and meeting with their employees and talking about their planning. And I'll bet almost half of employees don't name beneficiaries at all. They just assume it's my spouse, or they assume that it's handled. It's not. And it's important to not only name them, but to review them and to have a record of them. So that's first. The other thing is understanding asset titling, because all joint ownership is not created the same. There are lots of different ways to own property with multiple people, whether it's with a spouse, whether it's with kids, whether it's with other people. And I'm not going to go into all the details of that now. I am just going to say that when you meet with your financial advisor or your lawyer or both, make sure that your assets, whether that's your car, your home, your savings account, that they're titled properly so that there is either survivorship, if that's important, or a beneficiary is named, if that's important, or it passes through your estate and your will and your trust, if that's important. And without trying to render legal or financial advice now in a blind way, I would say every situation's a little different. But that's where we see a lot of mistakes before we even get to the legal planning. And we do have folks who come to us for financial advice, and I'm surprised that maybe a third don't have wills at all. Or legal documents at all. And then beyond that, even those who don't have beneficiaries properly, or they have assets that are titled in a way that don't make sense, or they're on their mom's bank account, or their kid is on their account. And there's issues with that, not only during your lifetime for liability, but also when somebody passes away. So without beating a dead horse, I would say that asset titling and beneficiaries are also important in addition to legal documentation.
Okay, may I add a couple of tax tips to that?
Absolutely.
Can't help myself.
No one listening to this likes taxes.
So,
And certainly I don't.
Okay, the first is Eric's point of not naming beneficiaries to an estate. Sometimes people think, oh, what's the difference? It'll get to the right people eventually. I just wanted to point out that it's different if there is an entity like an estate as the beneficiary versus an individual as the beneficiary. There are shorter periods where the payout can be made, and so it's less tax efficient. For example, if your beneficiary would be a spouse, the spouse can roll over and have the retirement account treated just like their own would be, where they don't have to take distributions until a certain age, and once they have to, it can be spread over their life expectancy. Where if it's an entity, it has to be distributed within a few years. The second is, in order to get the most bang for your buck, if you're charitably inclined, the best place to give your charitable dollars from is from your retirement accounts and your beneficiary designations, because charities don't pay income tax, individuals do. So if you pass your retirement account to an individual, if it's $1 million account, maybe they're actually really receiving $600,000 because it's all pre-tax money, and taxes have to come out as the money is paid. If it's that same $1 million, the charity gets the full $1 million because they don't pay income taxes. So, the other side benefit is you can change your beneficiary designations for free as frequently as you like. You just drive your financial advisor a little crazy with all the forms. So.
First of all, we're crazy when we met you, so it's all right. There's more to it than that, though. And so I want to caution folks not to run out and necessarily make those changes today, because if you want to leave some money to charity through a retirement plan, you want not to have both individual and entity beneficiaries on the same account. There's ways that you want to set this up to make sure you don't accidentally hit our third rail. So get advice on this: legal, tax, financial. It's not simple, it's not straightforward, but it is important.
Exactly. And probably the most important message that I can give of all of this is that it's so important for your professionals to be coordinated. Your attorneys and your financial advisors and your accountants should all be coordinated so that we're not doing things that defeat each other's goals, and that everything will make sense.
I agree entirely.
And I love that we're getting the financial and the legal point of view on this. So I'm actually going to add my young person point of view, not saying that you guys are old. But one of the things when I was setting up my accounts and my beneficiaries, my first thought was, I don't have kids, I don't have heirs. Like, I can't legally give my retirement accounts to my dog, though I would if I could. So I set my beneficiaries up to be a charity. I believe if I die, everything goes to St. Jude's Children's Hospital. And once I do have kids or get married, I know I can change that. But right now, considering I have nowhere else for it to go, sorry, mom and dad, it does go to a charity. So even though I'm still young and it's not a huge amount of money, I still get to feel a little bit good knowing that I will do something good with the small amount I have. So this is something that you can think about even if you are still young and kind of just getting started.
Jill, for the record, she did just call us old.
Yeah, I know. I'm still a year older than you. So that really hurts.
Well, it's nice that I'm the baby of some conversation.
I'm just trying to slide it in. So we've talked about the different ways we can do this, but Can we talk about maybe what to do first and how we really get started in doing this?
I'll take first stab at this, and then Jill, you can jump in and add to or correct if you'd like. I think it always begins with inventory. It always begins with figuring out where you are. Before you can ever plan to know where you're going, you have to know where you are. And that's financial, it's legal, it's familial, it's all those different ways. It starts with a conversation with your spouse, if you're married. It certainly starts with finding the right co-pilots and advisors for this. This is not something I encourage people to do on their own. There's plenty of DIY stuff out there. To me, this is not one of them. To me, it's important to have a lawyer and not do this online. It's important to have a financial advisor, even if that financial advisor is only looking at your world for a finite period of time. And is able to, on a project basis, look at this and help you get it set up. And I think it's important to make sure that, to Jill's point, your advisors talk to each other. You're going to want some tax advice. I'm not a CPA. I'm also not an attorney. So it's important that we work with those folks and that we work with your team already. And so I think it begins with inventory. It begins with communication. And then the next step is to engage advisors. And if you're not sure where to find those advisors, if you have a financial advisor, ask your financial advisor to introduce you to an accountant or attorney. And I would say the same thing in other ways. If you have an accountant, ask your accountant, who can I use for the legal or the financial? If you don't have that, you certainly have family who, if your parents or siblings or others are working with professionals, ask them, how do you feel about them? Is this a good fit? And then interview a few. You're going to find financial advisors. If you interview 5 financial advisors, you're going to get 5 different, not necessarily strategies, but philosophies. If you interview 5 accountants, if you give your stack of stuff every April to 5 different accountants, you're going to get 5 different tax returns. And attorneys, same way. There will be some things that they all have in common. There'll also be some things that are nuanced. And so just make sure you're comfortable. Make sure you feel good about the folks you're sharing these intimate details of your life with, and just get going. And I think the time to start is 5 minutes ago. I don't think there's ever a bad time to start. So, Jill?
Okay, so I agree with you that the personal referrals are key here. I think the one with the flashiest ad on TV isn't necessarily the one that's going to be the right advisor for you, or getting your, financial or legal advice from, someone who wrote a book that's general to everybody. Don't assume that applies to your specific situation. So I feel strongly with the personal referrals, and I agree that professionals are great referral sources to other professionals. From a nuts and bolts perspective, the way that we do things with estate planning is the first step when we're contacted by a prospective client is send out homework to do that inventory like Eric mentioned. So the 2 forms that you get, one is an estate planning inventory to get an idea of what you have and how it's titled. And for a lot of people, it's a very educational experience for them because they haven't looked and then things aren't how they thought they would be. So it's a really helpful process, and it's helpful for after the process is over, if anyone else ever needs to step in, they'll be able to see a roadmap of where their things are. The second part that we do is the family and personal questionnaire, the who's who are the parties, who are the players, and what's some of the background information. And that's important to have organized before you even step into that initial meeting. Otherwise, I just don't think that initial meeting will be very productive. And for us, once we have that initial meeting, it's a matter of determining if it's a good fit, of determining what plan makes sense, and making a decision whether to proceed, and assuming all of it happens before it's over, coordinate with the financial advisors to make sure that the beneficiary designations and the asset titling all coordinate with the plan.
Before we move on to questions, I do want to let everyone know that we put together a free download. Do you guys want to talk about what this is and how it can help people?
Sure, but Jill gets the credit because we have had, unfortunately, this year we've had several clients pass away, and a lot of times what heirs ask for is there a checklist, is there a guide, is there a how-to, and we never actually had one. We walked folks through it, and we certainly have done that countless times, but we didn't have we didn't have a resource. And Jill was the first person I thought of, and I called her and said, do you have this? And she said, yes. And she sent it to me. And I said, wow, this, if we combine the legal and the financial, this could be an incredibly powerful piece. And so we did some wordsmithing and we did some creation. And Jill, you get credit for the initial idea. And I think what we've come up with here at planningafterdeath.com is a very useful tool for not only when somebody passes away, but even if you're preparing for that. If you've got a parent in hospice or something and you know you're going to have to do these things, it's not a bad idea to be aware of what some of those things are in advance.
I agree, and I'm so glad that you approached me because I only, had it from the legal perspective, and you added some valuable parts from the financial perspective, and of course, Sarah made it all pretty and usable, and all the things that are important for people to, have it be a functional document. So I do think it is a good resource when people are at a, very difficult time. We were hoping to create something that is easy to navigate and just give you an idea of different steps to take to navigate through the process.
Yeah, so if anyone wants to download that free checklist, just go to planningafterdeath.com and there'll be right on the homepage a spot that you can download that from. So now let's move on to a couple questions. And if anyone else has questions they haven't submitted yet, this is a perfect time to do so. So we got a question from Kimberly, who asks about changing states. She moved from Maryland to Delaware, and there's a special form she has to fill out so that her executor doesn't have to leave the state. What are the things that you really should be keeping in mind when you are moving?
So, as I said, the documents remain effective if they're created in one state and they're still effective in the next state. But a lot of states have different forms, particularly when it comes to the financial powers of attorney, that are easily recognizable by the banks in that state, and it'll just be easier to implement. So it's not that your current one becomes ineffective. It just might be harder to use. And then finally, there could be different tax laws. And yes, there are also differences with executors. For example, Maryland allows you to have an out-of-state executor as long as you have a resident agent in the state of Maryland, meaning a person who can receive papers if the estate gets sued. As long as there's something physically located here, it doesn't have to be the personal representative. But then a state like Florida does not permit out-of-state executors. So your plan may not call for anybody who's located there, but once you move to, Florida, then you may want to consider, do I have any local options, or should I work with an attorney and get to know an attorney that can serve it as an executor, since my out-of-state family can't?
And just real quick on taxes, federal estate taxes right now, the limit is so high that most families, the vast majority of families in the United States, are not going to be subject to that. But there are estate and/or inheritance taxes at the state level with much lower limits where it does impact families, especially when there's life insurance, because generally it's based on the death benefit, not the cash value of a life insurance policy. So when you move, familiarizing yourself with those rules matters. There are some states that have an inheritance tax that's payable by those who receive money. There are some states that have an estate tax that's payable by those who leave money. And there's some states that have neither. And then there's 2 states that have both. The great states of Maryland and New Jersey, in their infinite wisdom, have both an inheritance tax and an estate tax because one just wasn't enough for New Jersey and Maryland. So it's an expensive place to die, but that's true. We're the only 2 states that have that rule.
Yeah, so moving to Delaware put you a step ahead already.
It's true.
You did good. Another question came in from Carmela. How do I take an asset out of a trust, like a savings account? Are you able to make changes?
Eric, you want that, or you want me to take it?
Well, I'll take it first, and then you can take it the legal perspective. It depends, of course, on the type of trust. If the trust is a revocable trust, which means that it can be changed at any time, and you're doing that for ease of distribution, then yes, you can change that anytime you want to. If it's an irrevocable trust, typically you can't change it, as the name would assume, or it's not as easy. And it's funny you mentioned one of our viewers in Delaware. Delaware is one of those states where probate is so expensive that revocable trusts are incredibly common. And so having a revocable trust allows you to title your assets in a way that they avoid going through your will and therefore the probate process, but it's fully revocable. You can change it anytime you want to. Jill, you want to talk a little bit about the irrevocable trust?
Sure. So if you have an irrevocable trust, that means that you put money in that is no longer yours. And the most common type of trust that's irrevocable during a person's lifetime is for life insurance purposes, because that's an asset that you won't really miss during your lifetime because the real benefit comes after you die. And it can take the entire death benefit of life insurance out of your taxable estate. So other times, a revocable trust, once a person dies, it becomes irrevocable. So it can't be changed anymore. Or if a trust is created in a will and it is created after the person dies and assets are distributed, that's not revocable. So if it's not a revocable trust, like Eric said, it really depends, and it goes to getting to the actual terms of the trust document. And usually an attorney can help review the document and see where there might be some wiggle room in terms of distributions. And if all else fails, there are also ways that trusts can be modified even after they're irrevocable through things like non-judicial settlement agreements or with court approval. So, depending on what the reasons are for trying to make a change to the trust, just because it's irrevocable doesn't mean it's absolutely made of steel and can't be touched.
And one more thing, when you talk about like a savings account for that example, getting it out of the trust and making a distribution is different than changing which bank it's with. So if you're with XYZ Bank and the trustee wants to change from XYZ Bank to ABC Bank, as long as the title is the same and it's still in the trust, generally, unless the trust prohibits that for some reason, which I haven't seen, but it's not impossible, I guess. You can change institutions as long as they're typically FDIC insured or they have the right the right qualifications. You're not necessarily stuck with that institution or entity, but you can do that without changing the status of the property or the ownership of the property.
And a trustee has discretion typically regarding the actual investment. So if it's the investment that you have concerns about, the trustees generally have discretion to manage the investments and change what those are.
Great, thank you guys for answering that. So talking about trusts, I feel like that's something that people usually associate with very wealthy families. What are some things that you guys might recommend if someone isn't necessarily that wealthy, but they still want to leave something behind?
Do I get this one, Eric?
Absolutely. I could see you were chomping at the bit. I can't go.
So I would say that the two biggest times where having a trust is important, the number one priority is if there's a beneficiary with special needs. So if there's a beneficiary with special needs and they could be eligible for government assistance, which can be incredibly valuable, it could be the way that they get all of their medical care taken care of, that could be extremely expensive. If you leave money to a person with special needs who is currently enjoying government benefits that are need-based, your bequest that you think is helping them can actually disqualify them from their government benefits, from their medical care, and can really hurt them. So absolutely, if it's a little money, if it's a lot of money, you do not want a beneficiary who's eligible for government benefits to receive it directly, and the trust is the way to make sure that there's money available for their extra needs that aren't available, that aren't being paid by the government without disqualifying them from their government benefits. The second obvious one is when you have minor children. Minor children can't and obviously should not receive money directly. So if you die without a will, and people are always surprised, not everything goes to the spouse. A portion goes to the spouse and a portion goes to the kids. Kids can't get money directly. So without a trust that's created by your will or through a revocable trust, then it has to be supervised through a guardianship with the courts. And the court has to get reports over the years of how the money is spent. You need court approval for certain distributions. And at age 18, the kids get everything, which is typically a disaster no matter how good your kids are. So those are the two essential times that I say a trust is necessary, regardless of your asset level. You have anything to add to that, Eric?
I would just say if you have beneficiaries, kids particularly, who either have addiction issues or gambling issues or profound marital issues, even without a huge sum of money, you might still not want to give them direct access to something that could hurt them. You know, if you have a drug habit and you suddenly wind up with a lump sum of money, there's lots of ways you can hurt yourself with that. Same thing with gambling or other certain things. So I would say those are the other scenarios where it doesn't matter so much how much it is. It's just a matter of not giving it to somebody outright. It's just not in their best interest.
And just to throw one more in there, I forgot to mention bankruptcy. If someone's going through a bankruptcy, you wouldn't want them to receive money directly.
Great.
Okay. And then one last question before I'll move on and let you guys kind of tell people how to get in touch with you if they would like to. Is there a certain age at which you really should make sure you have some kind of estate plan, or is this something that you don't need to do until you're not my age?
I think the day you're the age of majority. You know, we tell our clients when they have kids who turn in most states 18 that they ought to have at least financial and medical powers. They may not need a will necessarily yet, although we could debate that, but they definitely need financial and medical powers because your parental rights end at the age of majority. So you can't even get their grades from college without them signing off that it's okay, much less making medical decisions or financial ones. And so having your 18-year-old sign a document that says, I'm naming my mom to make these decisions for me, for example, makes it much, much easier, because otherwise mom's in the hospital saying, this is my son and this is what I want. And the doctor's saying, this is an adult person and I can't take that advice from you.
Jill, anything to add?
So I would say Eric's absolutely right with the incapacity documents. I, am commonly one of the last stops before a kid heads off to college and the parents realize that, they won't be able to have access to medical information. Doctors won't talk to them. So those are important right away. I think as soon as you have assets in your own name, it's important to have a will. But I would say if you're dragging your feet a little, I think it's critically important by the time you have children, because the will is the only place where you can designate a guardian for minor children. And so if you don't, the court designates the guardian, and you can have the situation where too many people are fighting for your child or nobody's stepping up for your child. So even if none of the options are good, I still think it's better for the parents to, make the least bad decision when it comes to guardianship rather than leaving it to the court. And yeah, I would say that's probably the latest when you should get yourself started.
Great. Well, thank you guys so much for answering all those questions. Is there anything that they should do to get in touch with you guys? And what is this fancy little QR code on the screen?
Sarah, you're the best person to answer that. This is your QR code. And you just, yeah. Obviously, our contact information is on the screen, our email address, our phone number. We would love to hear from anybody who's interested in finding out whether BFG is right for you, for your family, for your planning, whether it's estate planning or financial. The QR code is a way to schedule an intro call with one of our financial advisors. We have a spectacular team here. And so if you just hover your phone over that, you can actually get to a calendar, schedule a call. Certainly there's no cost for that call, but it'll be an opportunity to get to know our team a little bit and see what next steps might make sense and figure out if we're right to help you.
And I don't have a Sarah, so I don't have a fancy QR code, but I would love to have one someday. Anyway, so you can either email me or call me, and I'd be happy to get the process started. And to just let you know that Eric has a great newsletter that he puts out. I have a newsletter. If you wanted to be added to that newsletter list, you can let either of us know, and we can do that. Mine come out quarterly. I don't know your distribution schedule exactly, Eric.
Ours are monthly, and that's also because we have a Sarah. Not just a Sarah, we have the Sarah.
Jill, we'll talk later. You might
thank you. And, yeah, I look forward to hearing from you.
All right, thank you guys so much for joining us. Again, if you want to reach out to either Jill or Eric, all the information is on the screen. Feel free to schedule a call. If you schedule a call with us and it turns out you really need someone on the legal side, we will connect you right to Jill as well. So thank you guys so much. We look forward to hearing from you, and join us for our next webinar.
Thank you for having me.
Thank you, Sarah. Thank you, Joe.
Mhm.